Thank you very much. I appreciate that. And we're going to kind of try to get back on track here with the time a little bit. And we've got lots of things. That's the only problem that I have in these kind of sessions. The things that I see, I just feel like there's so many things that I want to talk to doctors about. And so I'll try to intersperse some of that as we go. First of all, though, I wanted to, all of you who are wearing red today got the memo from the governor that this is recognition of women's health and especially heart disease. And so some of you got the memo and some of you didn't, so we're good. I was with the Medical Association for a number of years, and I think that has given me great insight when I came over to the medical board. I've worked now over 30 years with physicians, and even in my current position, when we see physicians in really the most distraught situations where they have virtually lost everything and close to losing their career, I still have a great deal of appreciation and respect for medical doctors. I think you rise above so many things in this society, and I think it hurts all of us when we see some of the things that go on. There's some real tragedies that happen. So with that, I just want to say that I have really appreciated working with many of you, with the OSMA, with OOA, with the DO board. We have a good working relationship, and I appreciate this session because the easier part about having the afternoon session is much of what we've covered has been covered in the morning. There's so many of the things that I have to almost kind of retell the story again. And so we don't have to really go through why there's a problem. We've talked about that a great deal. And so I usually put this up here because it's been a long time since I got in trouble playing doctor, but it certainly wasn't like this. Being a doctor today is tough business. Lots of paperwork, lots of regulations. This whole afternoon is going to be filled with that. You've heard some of that this morning. And I know you even have some days like this where, Miss Smith, I'll give you a second opinion. And I know there are days like that. And I appreciate the fact that you are under the gun in a lot of areas. Pain treatment is just one of those. And so we're going to talk a little bit about some of the things that we can do. I wish I could say that the situation is going to solve itself, but it won't. Unfortunately, we're going to have more regulation. I think we're going to see that as we go through some of these slides and as the legislature kicks up next month. This has already been mentioned, so I'm going to go through these two slides real quick. The ASAM, Addiction Medicine Society, just came out very recently. Dr. Sandbar mentioned this as well. And the main thing that I just carved out was patient education and doctor education. And guess who gets to educate the patients? You do. So you've got double chores, not only to find out yourself how to be better at pain management and regulating pain, but also to teach patients. And that's a tougher job because medicine has changed over just the years that I've been connected with doctors, in the fact that many patients come in with a list of items that they want, as opposed to the physicians indicating what they need based on their diagnosis. So we'll talk about that a little bit too. And as I talk about this, I just wanted to mention, because we deal with a lot of physicians that get hooked up on substance abuse and have personal issues themselves, and I wanted to just put in a word about the Oklahoma Health Professional Program, OHPP, that Lanny Anderson, Merlin Kilberry, and now Robert Westcott heads up and work with a great number of physicians in Oklahoma that are trying to get into good recovery and get back into a good, safe practice. And so I hope that you will utilize that program. It's sponsored by the OSMA and PLICO and the medical board, osteopathic board, and we all have a hand in it because we feel like it's important. And so if you have a colleague or yourself, you need to get in touch with them, and they can help you get your life back on track. So I just want to mention that. Complaint process. Let me get back to complaint process. I've just got some basic bullet points there. We receive complaints from just about anybody. It can be from patients, other physicians, pharmacists, patients' family members. Then we try to determine whether there is any real substance, real merit to that complaint. And I would say probably we get 600 to 700 complaints a year, and really we'll end up calling out of those probably about 100 that will actually rise to some level of concern to the point where we might open an investigation and go forward with it. I put clear and convincing in there so that you understand that it's a higher level of evidence required for complaints with the medical board than it is with malpractice. And so we have to look at it from a very strict standpoint to make sure that the evidence is clear and convincing. And if there is an investigation open, then we gather obviously the facts and details and witness interviews and so on that we need in order to support that accusation and see if there's any merit to it. The board staff, at this point in time, the medical board members are not involved up to this point. Medical staff determines if there is clear and convincing evidence once all of that is gathered. And we decide whether to close that case or to issue a letter of concern or to file a formal case. Now, one of the things that I think is unique about Oklahoma compared to many other licensing boards and disciplinary boards in other states is that we have an informal letter of concern. And this is where we utilize letters of concern for actual medical practice situations, concerns, that we can have the doctor come in, sit down, and talk with usually either Dr. Zumwalt, who is the board secretary, or Dr. Eric Frischi, who's our medical advisor. Come in, and we sit down, and we just talk about it. Here's the concern that's been raised. It's not a public issue. It's not a formal complaint. It's just something we think that you as the physician or your office staff need to be aware of, and maybe there's some things you can change in your practice, and that's all the further it goes. And we issue about 35 to 45 of those a year. And it helps get the physician's attention because it is kind of a wake-up call. There may be some things that they're not even aware of in their practice, and this gives them an opportunity to tell their side of the story. And sometimes after they bring in some additional records or something that we didn't have, then that's all there is, and it doesn't go any further. And I really think that's a big advantage for Oklahoma, that we can utilize that and it doesn't have to go to a serious formal board complaint. Board staff is available if it goes a little further. We meet with the doctor, sit down and talk to him about either the letter of concern, and those are not reportable. They're not on the data bank or anything else. Or if it starts to go towards a formal hearing, formal complaint, then we can meet with a physician. If they have a lawyer with them, then we can sit down and meet and see if there's any resolution to that complaint, if we can come up with some kind of settlement agreement. From that meeting, then we try to determine whether we're going to go with some kind of settlement agreement or just go to the board for a full hearing and let the 9 members of the medical board hear that case. All settlements, every decision based in disciplinary action, every decision has to be made by the board. And there are 7 medical doctors and 2 public members on that board. And so if it goes to a hearing, if it goes to that point, and probably out of 100 to 120 cases that we will actually see in any one period of time, year period of time, we will usually have about 30 to 40 cases that will actually get in front of the board. So when we start talking about some of the rule changes that I'm going to talk to you today, realize that it's a very small portion of individuals that really even get to in front of the board with any kind of disciplinary action. Okay. Interviews. During our investigations, obviously, we talk with the complainant, any other witnesses that pertain. We'll talk with the doctor, find out the doctor's side of the story. We'll look at, find if there are other witnesses, depending on what the allegations are, of course. We'll look at medical records, and that's the key thing we're going to be talking about today. Dr. Hook can tell you how many times they have seminars for PLICO members and talk about the records, the medical records, the documentation over and over again, because that is the key link between you and either having some problem in court or in front of the board, if it comes to that. So the office charts, obviously corresponding hospital charts, if they apply, are very important. Now, let's talk about the rule change. This is very timely in this presentation because we are getting ready to present a rule change to the legislature. OSMA and OOA a few years back helped pass some legislation that all rules now have to go through the formal process of legislature, just like bills have to go through. So there will be a number of hearings. The hearing on this rule in front of the board will be on March 8th at 9 a.m. Now, that's on a Thursday. Most of you are going to be practicing. So if you have a problem as we go through these, you certainly can email me, you can call me, express your concerns on it. That's what it's for. And on March 8th at 9 in the morning, on Thursday, we're going to have a public hearing in front of the board, and we'll have individuals there that can speak to or for it or against it or whatever they want, or make their comments on it. Then it has to go through the legislative process for both houses and then on to the governor. So it's got lots of ways to go, so don't overreact to this. Part of the thing that we're trying to do here is we're trying to be, the medical board is trying to be proactive in some of the things that we think are coming down the pike. And that is things that you've already heard about mandating use of the PMP, mandating CME credits for pain management before you can practice pain management, or certain CME classes before you can get certain designated CME classes before you can get licensed, and so on. So there's lots of things out there. The reality to this is the whole issue, the big global issue is that doctors are probably responsible for about 20%, a little over 20% of the whole issue of overdose deaths. So it's a very small part of it, but most people, the legislature, the public, patients, when they think prescription drugs, they think doctor, those who can write the prescriptions. And that's why we're having these educational processes like today, and we will try to repeat this same session in Tulsa in the fall. So let's look at it. The first one is pretty straightforward. It just says that the state of Oklahoma realizes that people need access to effective pain relief. This has been the same as it has been. This rule is in effect now. It is the effective law right now, currently. You'll see the underlying portions are the things that we're talking about submitting for changes. Evaluation of the patient, how many times have you heard that this morning? I mean, it is so obvious to doctors that we keep coming back to that issue of proper evaluation of the patient. Medical history, physical examination, documented in the records, listing all of the conditions. I think several of the speakers, Dr. Winicky and others on the this morning mentioned about the physical and psychological issues, psychiatric issues, comorbid issues that are going on with a lot of these same patients that need to be recognized. So one of the things that we are adding at the bottom is refer to the physician-patient relationship, the definition of that, and that's what we're going to look at now, and this will come into face-to-face, and I'll talk to you about that. There are two things in this definition here that I want to just touch on because they're going to. The red portion is what is in the law right now. That's what we've always been dealing with. Over the last 2 years, the medical board defined the physician-patient relationship. Now you would think that everybody would know what that is, that medical doctors would just understand what that is. And for years, we didn't have that definition. It was just, we understood what that was. But several years ago, with the advent of internet prescribing, teledoctor kinds of medicine going on, where physicians were not seeing the patient at all and diagnosing and prescribing narcotics over the phone and over the internet, it became concerning as to what is a legal definition of the physician-patient relationship. That was the reason. Now, I knew, I'm not a lawyer, and I'm not a doctor, but I knew that the minute you start to describe something in writing, that it just opens up a whole can of worms. The Osteopathic Board didn't do this. They understand what a doctor-patient relationship is about, and they essentially enforce what this says. They just don't have it in writing. And I knew when we did this that this was going to cause problems, because the minute you start to say face-to-face encounter, now most doctors are going to say, well, of course you're going to see the patient. You're going to see that that's who the patient is, their medical condition, their assessment of their diagnosis, and so on and so on. It just seems obvious, but when you put face-to-face, it makes it sound like you have to see the patient every time they walk in your door, and that's not the case. It also says as any supervised individual can act as seeing that patient on behalf of the physician. Just what you do now with utilizing physician assistants and nurse practitioners and other nurses in your office. Okay, so my point is don't get, they are not mutually exclusive. Don't get hung up on one little terminology. Face-to-face just means that you're going to see the patient occasionally. Our internet prescribing rules and guidelines say that at a minimum you ought to see the patient once a year. And all we're trying to say is that it's your medical judgment. If you want to see the patient once a month, every quarter, every 6 months, that's your decision. We're just saying that at least initially, you ought to know who that person is you're treating. That's what the face-to-face says. So it's not mysterious. We're not going to go out and arrest you for not seeing the patient on 6 months or 3 weeks or whatever, okay? It's just, that is not the point. It's the point to try to say that some of these things are just common sense in the practice of medicine. The underlying portion, however, is starting to kick up some dust. And we, what happened is that there were some doctors that were concerned that they had to see patients that were coming into their offices to get immunizations. You don't have to see the patient for immunizations. You're not diagnosing a medical condition. You're not treating a medical condition. You are injecting a medicine into somebody, and so somebody needs to be there to watch for a reasonable amount of time to make sure that there's no side effects or reactions, okay? But we're not expecting you to have to see the patient. The nurse in your office can do that if you're doing that now. That's just not a problem. And yet, there are a number of entities in the state health department and the major health departments felt like that was a problem for them to carry that out. And so we've made this underlined addition there. It says that the physician-patient relationship shall not apply to the provision of medical immunizations by the health departments with standing orders and policies that they make up. Now, what's the problem? School nurses, Indian Health Services, VA centers, you know. So this underlying portion has either the option of being taken out or expanded to be about 3 paragraphs to write every possible option that can be in there. That's not what the intention was for. It's just to say that immunizations don't fall in the same category because you're not diagnosing and treating. So we'll see how this part of the rule comes out once it gets into the legislature and that process. treatment plan. Again, there's no addition here. The red parts, I'm just kind of highlighting those parts that I think for this discussion, things have been repeated. You know, you need to determine on a regular basis how the people are doing, how the patient's reacting. Are they getting better? Are they, as Dr. Anthony said, are they being able to function? Can they work? Can they do their activities? So, and adjusting that drug therapy. The ones that end up in front of the board, quite honestly, are the ones that have little to no documentation about anything. Otherwise, if they were fairly well documented, we'd have a letter of concern if we felt like there was something meaningful there. But most of them, we look at your records, and it doesn't go any further than that. We just close it out and put it in the confidential file. So my point is, the ones that make it in front of the board are aberrant practices. And you saw a little bit of that with Dr. Sandbar and some of the other examples, where there's very little documentation. So that's what we're really talking about. Okay, first outline here. The physician shall discuss the risks and benefits of the use of controlled substances with the patients. Shall instead of should. As a couple of the speakers mentioned this morning, I used to give talks 7 to 10 years ago that said, yeah, you could do that if you wanted to. You can prescribe any amount of CDS that you want. It doesn't matter. Well, now, because of the results of what we're seeing with patient studies, amount does matter. It is important. And so we're just saying that we're telling the legislature through some of these changes that we think it's serious enough problem that some of this should just almost be expected that you're going to do this. PLICO certainly wants you to tell the patient of the risks and informed consent. So it's kind of endorsing or emphasizing what we think should be done already. Whether or not the patient is at high risk for medication abuse. You've already heard the doctor speakers here talk about all the risks that are available. So it's just saying take an extra measure because you don't know the ones that are going to be drug dependent or drug addicted or have neither issue. So whether or not it's an issue, you need to take the same kinds of steps whether you can determine ahead of time or not. Shall use a written agreement. I learned something today, I guess Dr. Winnicke said something about contracts or agreements or it's something where the patient understands what their obligation is to do to be compliant. And it says what you're going to do and what you expect from the patient, so that they understand this is serious business. Again, periodic urine. It doesn't say you have to do it on every time. It's again, a medical judgment. Now, here's the one that somebody may have a problem with. B, documented access to the prescription monitoring program, PMP, and periodic pill counts. Now, documented in the medical charts that you checked on the PMP. That's all we're saying. Not every time. You don't have to do it on a consistent basis. If you've got the 80-year-old grandma that comes in and you don't think there's any problem, we're not asking that everyone has to be, that you have to look at the PMP. It's a tool for you to use. That's what we're saying. And it's a great tool. It's even better now because it's at the point of sale when that information is. So it's quick feedback. Are there individual problems that come up? Absolutely. And Mr. Weaver will address some of those issues and things. But it's a great tool. And all we're saying is we don't want it to be mandated for every patient you see by a legislative edict. We'd rather it be by rule and say that this is a medical tool for you to use. Periodic pill counts, again, that depends on the patient. That depends on what the problem is. Those are things, as you heard, that can help in some situations and makes the patient more accountable. That's the only change on that. Again, a couple other in periodic review. These are things that you would think, again, we all know this. You ought to review the treatment plan. You ought to review the charts periodically. You ought to see how the patient's doing. Physician's evaluation of the progress in the chart. So that I think Dr. Sandbar called it, the course of action or how they're doing, those kinds of things. That's what we're talking about. And again, these are the things that you would have to, that we're saying you need to have there, whether it's a medical malpractice case or an issue in front of the board. These are the things we're going to ask you, do you have these? Is this something that you have present? And the more things you have substantiate that you're doing okay. If the patient's progress is unsatisfactory, then you should look at it and assess it. Should you refer them to somebody? Should you change the modality? Should you offer some other kind of treatment? Another special attention shall be given to those patients with pain who are at risk for medication use and abuse, as evidenced by number 3. So it's just saying here's some things to take care of. Look at other things like do they have depression? Do they have bipolar? Are there some other conditions that may be contributing to their misuse or abuse of substances? Medical records, I don't need to spend a lot of time on this. This is just saying, emphasizing that you shall keep them current, you shall keep accurate records. You do that now. Records shall remain current, maintained. Again, it's just re-emphasizing. Physicians shall keep accurate and complete records. None of these are, again, mutually exclusive. We're not going to haul you in and say, well, you didn't have informed consent documented in there, or we don't see instructions and agreements in there. It's collective. Can we read the chart? Not me, but can a physician read the chart and tell the course of action that you've done? Can they tell what your thinking is medically? That's the point. To prescribe and dispense. Let me just say one thing about dispensing, because it comes up more and more now in this day and time. In order to be a dispensing doctor, all you have to do is go on to the medical board website and look for dispensing doctor and check yes. That's it. No special license. You don't have to pay anything for it. But the responsibilities for being a dispensing doctor are fairly hefty. You're running a pharmacy now. It's not just you handing out samples. Now you have to properly label. You have to make sure that you're following some of the pharmacy rules and the federal regulations that control dispensing. Can you do it? Yes, absolutely you can do it. You don't have to have any special training or license or anything else. But it does require some additional attention, and part of that is making sure that you put that information that you dispense to that patient in the PMP if it's controlled substance. Okay, so just be aware of that. It's an easy process. So with that, I will leave that up for questions after the designated time, and thank you very much. Appreciate it.